believe this is on for guardian ad litem report review, which I did receive that report. I think that was filed August 30th. I believe that's all that's on for today.
That's my understanding as well. I've received the GAL report. There's no motion pending.
Right, and I did receive a declaration from Ms. Boaglio, which again, I don't have a motion pending today. So at this juncture, I don't have there's nothing else to address on this case. So if there's somebody wants to file a motion, I'll be happy to look at it.
Thank you.
Okay. We'll strike that today. I'm not seeing Commissioner Carmi yet for some reason. And Nicole Ramos, if you could step up to the counter, if you could. And this is on for setting a 26I conference.
That's correct.
Check here.
And I just asked the person that's seated with Ms. Ramos to identify themselves.
I'm victim's advocate.
And that's fine. I have no objection so long as you don't give it this.
So I didn't have a response. Are you opposed to setting a conference with Ms. Baldwin?
No, Your Honor, I've been seeking legal advice, and I just spoke with Northwest Justice.
Okay.
And so he referred me to Wakaikam Legal Aid, and he said to ask for adequate time to be able to respond and to obtain representation with them. He said it would be probably about 3 weeks before I would hear from him. And he said like about 30 days is what he would.
Where are we at on this
advise.
case, counsel, as far as that
And
goes?
because I do want to comply.
Okay, but this is essentially a conference for you to talk to Ms. Baldwin about discovery responses.
Right, and he did say that some of those discovery questions are kind of like a backdoor discovery for the criminal case, and he felt that it would compromise the safety of my children and myself, and that I should seek, I need legal representation.
Ms.
Definitely,
Baldwin?
so.
Thank you. So the simple act of getting a discovery conference at this point has taken months. You see that the original letter that I wrote to her is written back in July. We have additional efforts to just try to get this conference set. And so the request now, and then even this motion is filed mid-August. There's no response. And here we are now in September. The idea that it would take me into mid-October just to get a discovery conference, when I've provided her a letter with all of the issues, point by point, an email with all of the issues point by point, and there's just no response, no communication, and she's just essentially saying, I'm just not going to communicate back. That's not acceptable. It's not reasonable in this case. So I am asking the court to provide the order that I requested, which requires her to engage in a CR26I conference. I'm asking that that happen within this week. I think that that's reasonable, especially because I've written a letter with what all of the issues are. So nothing is a surprise. That's been pending since July. And I am asking for fees. I'm asking for $1,050. That's representative of 2 hours of my time. At this point, I've put in a much more significant effort in getting a hold of her than I have essentially any other counsel where I can just schedule it. At this point, we've put in a lot of effort. That takes time. That costs my client. And the answer here is just kick it down the road. That's not a reasonable response for where we are.
Okay, well, I don't think I can grant fees under the rule without there being a 26I conference, but so I'm not going to go order fees at this point. I will set a date. Let me see here just a second.
And Your Honor, I have reached out to her office a few times just to keep touch bases and let them know that I am, that I was reaching out to Northwest Justice, and I finally obtained an intake with them. And then I did get to speak with someone.
Okay.
And then Friday I did let them know that he's referring me to Wakaikam.
All right. Well,
and keep in mind that I have been starting like the video visits. And so that's been taking up 2 days of the week. I do counseling and the video visits, and the video visits I'm paying 50% for. I'm on TANF now. I don't even get what they're asking me for. So,
okay. Well, I'm going to set a conference for next Friday, the 13th. What time would be workable for both of you? And that's simply, it can be a phone conference. It can be in our office, whatever your preference is. It's just to discuss the issues that are pending here.
When he was saying that the prosecutor would need to be present,
I'm sorry?
that the prosecutor should be present.
This is a civil case. This is
I
prosecutor
know,
not
but they're
involved in this
asking
case.
questions that don't obtain to this case. So
Well, if
he's
the
asking
prosecutor
that the
wants-
prosecutor.
If the prosecutor wants to get involved, they certainly are able to do that. But at this point, this is you are
And we
representing
did, I
yourself.
did, all this time, Aaron, when I had representation, we have been answering all the questions that they've been asking.
Okay.
And we have been in line with everything. And we've been very busy with a lot of other things.
Ma'am,
This last,
There's a
we've
whole
been
list.
in the DVPO, and
I'm
that's.
going to
been-
object at this point.
Okay, let me
So-
stop you for a second, ma'am.
We have been
This-
working on
ma'am?
all of this.
The last time I did this, I had to call a deputy. I don't want to do that again. Okay? I'm setting a discovery conference. That's all I'm doing. I'm not making any rulings other than I'm setting a discovery conference for next Friday.
Right, without representation, I don't really understand and I don't know how to navigate myself through this system. And just because I can't afford a representation, I'm trying to seek representation.
I understand that.
Thank you.
I
It's not that
understand.
I'm trying to be disrespectful or anything.
I understand. I'm simply setting a discovery conference on the 13th, which is next Friday. You could let the attorneys know that. They can let the prosecutor know that if they want to be involved, they certainly can do that. Set it up for the 13th, and what's a workable time for everybody?
I could do 8:30, I avoid 9, but 8:30, 10:30, 11:30 should all work. I can do essentially before the 9 AM docket. I can do what I anticipate would be after that.
Are there any, do you have any appointments already set scheduled on the 13th,
Well,
ma'am?
that's what I'm working with Beth Fellows and also with Charlotte Rouge. So we have 2 days that we schedule appointments.
Okay, well, do you have anything scheduled next Friday on the 13th?
As of now, we don't.
Okay.
I
I'm
do
setting it
like
at
to
1 o'clock.
prioritize
1
that
o'clock,
first
okay.
because then she'll probably.
Okay, I'm setting it at 1 o'clock on the 13th. And you just need to have a conference. And again, you may want to talk with the lawyers, let them know you've got that set.
Right, that's what I'm seeking legal aid for.
I'm sorry?
That's what I'm waiting until they respond. He did refer me and he
Okay.
said it would take about 2 to 3 weeks.
Okay,
So
let them know. you've
that's why I
got it.
said it wouldn't be reasonable to schedule anything until I,
Okay, let
but
them
I
know-
understand. Go ahead and schedule it for the 13th.
Okay, let them know you've got a conference on the 13th, and if they want to get involved, they certainly can do that.
The who?
Northwest Justice or the prosecutor, if they want, if they think
There's
there's an
nobody
issue.
available. That's why they're referring me to Wakayakam.
I
there's-
understand, ma'am. I'm setting a conference on the 13th at 1 o'clock.
Your Honor, would you be so kind as to hand out a bench order and I'll just write a bench order that's your order?
So, and you can, that'll be by phone, I assume. So,
And I just ask that she say if she wants to review the order, she can. If she doesn't,
Right.
that's fine.
if you want to stick around and take a look at that order, make sure it says what I said, and then we'll come back. Well, we won't come back for everything. I'll schedule it right now. Okay. I believe Commissioner Carmi just logged in.
I am here. Good afternoon.
Good afternoon. We have a couple of matters, I believe, that are yours.
Yeah, it looks I have the Thompson v. Thompson matter. I have the parties present on that.
I'm present, Judge. I'm in the courtroom.
Oh, okay, great, Mr. Zandy. And do we have Kurt Thompson?
I thought I saw him on the lineup. Maybe not. Maybe that's Kay Thomas. I apologize.
Yeah, that's what I saw too. I'm looking, this is a large Zoom screen. I'm just looking to see. Okay, well, Mr. Zandy, let me turn it over to you. I did see your presented order for my ruling and a proof of service to Mr. Thompson. What are you asking for today?
That's pretty much it, Judge. Just to sign the proposed order as drafted so we can get that entered. There's already a built-in review for later next month to hopefully ensure compliance that was set by Your Honor to October 8th at 1 p.m. And at that time, I don't know if you want to hear it or Judge Bashor or whoever, it doesn't matter to us. Unless you want to assume that because you did enter the order on the contempt.
Yeah, I'm happy to stay on this for our next setting. I did get the proposed findings and I did review them. I don't see Mr. Thompson here, but the order does comply with the contempt ruling I made, so I will sign it. And then I'll get that filed with the clerk. I do have the copy of it. What was the date that you wanted, Mr. Sandy?
October 8th
Okay,
at 1 p.m.
we'll put this on for October 8th at 1 p.m. And I will send an email to court administration so they note that for me at 1 o'clock.
Excellent. Thank you.
And then Ms. Powers, I have the Purcell matter.
Yes, I'm here, Your Honor. We have just been waiting for the court to appoint an attorney for the respondent in this case. And last I checked, it looked like an attorney had not been appointed yet.
That is correct. Mr. Angelico, I assume you're just here because you represent respondent in the protection order case. Is that right?
Yes, and that's kind of trailing this case, Your Honor. We were expecting, I did send the link. Mr. Young is in an adult family home up north. I did send them the link, so if we can inquire to see if he's on the Zoom call.
I do
Yeah,
see him here. He's the man whose last name is spelled Jerop, J-E-R-O-P. At least that's who had appeared
That's
last.
the phone I'm using, the person's phone I'm using, but I'm here.
Okay, perfect. Thank you, sir, for being here. So I guess as you heard the attorney state, we're still looking for an attorney for you in the family law matter. I did approve appointment of counsel since there is a restraining order requested in these temporary orders. So all I can do today is give you all a new date for hearing on the temporary orders. Ms. Powers, do you have a proposal?
Do you have any guess of how long we're looking until an attorney's appointed? I think we're kind of stuck until that happens.
Yeah, why don't we set this out if it's acceptable to your client? I don't want to delay this further, but if we did 3 weeks, would that be agreeable to the parties?
That's fine with me, Your Honor.
Is this for the continuing to find an attorney to represent me in the dissolution case?
Correct. Yeah, we're gonna still appoint you an attorney for the dissolution. So if I set this out 3 weeks, my hope is that'll give that attorney time to get up to speed on your case and be ready to discuss temporary orders on September 24th. Does that work for you?
I guess so. Mr. Angelico has the contact information for me about how to reach me, and both at the house that I'm living at on a landline and the cell phone number for the person, the landlord who owns the house, and the email for the Zoom link.
Okay.
So Mr. Angelico is kind of a helpful contact person.
Okay. Sounds good.
And can we inquire, Your Honor, our other case is scheduled for the 9th on the no contact order docket. And we had been continuing this along because
Mhm.
they were kind of, if they do grant an order in the dissolution case, they were going to dismiss that one. Do
Okay.
we need to appear on the 9th to continue that, or is Your Honor able to do that?
Let's have you appear on the 9th just because I don't have the reissuance orders with me right now. So if you all could hop on to my protection order docket on the 9th, we should have you set for 9 a.m.
I believe that's the case, Your Honor.
And I can call this case first, get that reissuance done, and then you all log out.
Thank you.
I don't know if I'd be able to make that at the 9th through my connections here.
You wouldn't need to, James.
Yeah,
I'll talk to you about it here later.
You'll talk to me about it later, Wes?
Yes, I will. I'll give you a call this week, James.
okay, so it sounds like Mr. Angelico will reach out to you before the 9th, okay? Okay,
He would
I'll set
represent
this
me in
on.
that. And it's another hearing for you to reissue a temporary order.
It sounds like that will be the request, but I'm going to leave that for the protection order docket. So we can make a record, okay? Okay, I'll see the
I'm a
parties
little
back September
confused,
9th.
I'll talk to you, James, and we'll discuss it.
Okay, so I'll see the parties Monday the 9th on protection order at 9 a.m. On this docket for the temporary family law orders, I'll have you back September 24th at 1 o'clock.
Thank you.
All right, thank you.
When is it, September?
There's one September 9th and September 24th. It's one thing, September 9th at 9 a.m. and another one
right.
at 21st.
All
Okay.
right.
Then do
Judge
you,
Basher, I think that concludes my matters.
I
do you
believe.
want them to repeat the
Thank you.
case so you can know?
And
Can you ask them?
Petrie?
No, I can't interrupt the judge now. It's the 9th.
Good afternoon, Your Honor.
Good afternoon. I think I saw Miss Bliss on here as well.
Yes, Judge, I'm present.
There we go. Okay. So I did have a chance to read both the motion as well as there was a brief response that was filed today. Did you get that, counsel?
I did not, but I anticipated, since it was such a short turnaround with the holiday, that something may have been forthcoming, or I was anticipating counsel maybe arguing on the docket.
Yeah, I did receive a response. It's 2 or 3 pages. It's actually 2 declarations. I don't know if you want to take a look at those before we. I don't have those available to get those to you. I don't know if counsel could email those to you.
I believe they were emailed to her just right after we filed it, within the past couple hours.
I'm not seeing any email, which is why I didn't have a chance to look at anything before the docket. So counsel, if you could re-email that to me, and Judge, if we can recall this.
I can
so
do
that way
that.
you can have a few minutes.
We'll come back to that then.
Thank you.
Let's just. So I did have a chance to review the filings on this case as well. Did everybody receive the response and everything? Okay. So go ahead.
Thank you, Your Honor. For the record, Megan Gilmore on behalf of the respondent and moving party, namely Jill Gibson. While this case may have been pending for some time, I think it's important to note the fact that at the beginning of the case, and roughly for half of the case, my client was the primary parent pursuant to the court's orders until the order changed December of 2022. As detailed in length by my client has made weekly, if not daily, efforts to comply with the court's order, progress this case forward, and have contact with her children. I can personally attest to the amount of work that both of us have done to comply with the orders and get this case going over the last 12 months. At this point, however, the case is simply not ready for trial. The children and my client are still engaging in reunification therapy. We are now 30 days from trial, and we do not have a recommendation from Ms. Dirks regarding ongoing visitation. We delayed bringing this motion in hopes that we could have that. However, at this point, we don't, and I simply think that it's going to be vital for a trial court to make a parenting plan decision on a final basis. Regarding the psych eval, we received an addendum last week as attached within petitioner's responsive materials. That was only received on August 27th. My client didn't have notice that this was going to even occur and didn't have the ability to respond. We have subsequently received communications from Dr. Deming indicating that she would be needs to do a supplemental report, and she has quoted costs for that. In other words, the psych eval is simply ongoing, and my client has the right to respond, and it's simply not the we're not to the point where the court will have adequate information regarding this expert. The court specifically ordered Ms. Gravina to take or provide an updated report in May of 23. We've received zero communication despite my client and myself's efforts since the fall of 2023. My office personally mailed the check for $500 to the guardian ad litem. Those funds were returned to my office. My office subsequently made multiple attempts to have her pick that up, and she failed to do so. At this point, the last report before the court was in February of 23, which recommended my client to have 50-50 visitation. The statement of concern that was filed subsequently thereafter in June of 23 recommended no visits until a CJAC interview was completed, which has now been completed 12 months ago. We requested discovery over 12 months ago that we just received on August 15th. It's also important to note that the prior trial dates, both of them, were struck by agreement of the parties based on petitioner's request for 90-day extension. So simply my client's request to set over trial to have the pertinent information in this case isn't her attempt to delay whatsoever. Simply, we just don't have the information that we need before the court. And again, it's in the best interest of the children to have a relationship with their mother. And the court isn't going to be able to do a parenting plan that's in the best interest absent this information. Just quickly addressing some of the allegations contained within the responsive materials. The children were not school age when the recommendation regarding reunification counseling was made. My client wasn't aware of any sort of vacation, so we're not trying to manipulate or cause hardship for petitioner in this case. I simply brought this because we waited and waited and waited for the reunification counselor to provide a recommendation. And I wanted to get it before the court, before the year, and I know for a deadline to ensure that both parties don't pay additional costs unnecessarily so in preparation for trial. My client does not deny the abuse, and the evidence will show once it's complete that the children and my client are working on this incident that occurred previously. So again, the court does not have enough information to move forward today. My client brings this motion in good faith. She simply just wants to be able to progress forward in a way that's in the best interest of the children. We don't have that information at this point.
Ms. Baldwin?
Thank you. For the record, I represent the petitioner Cameron Gibson in this matter. We're asking the court to allow our trial to go forward. Just for explanation, we didn't receive the order shortening time until Friday. So our materials certainly came in at the last minute, but with that understanding. And time was shortened on this matter, I think, with undue haste, given the fact that there's no sort of perilous emergency that's happening in this case. This is a case that's been pending for over 3 years at this point, and counsel has been involved for more than a year, since July of 2023. We have currently sitting an October 7th trial date. We're still more than 30 days away. No one has set any depositions for any experts in this matter. So it's not as if there's some barrier to doing so. There is still plenty of time if counsel feels that that's necessary in order to prepare for trial. In this case, we have a number of experts who have provided reports. None of them are a surprise. It's not as if we are adding a new expert at the last moment. These are all experts that have been on board. Everyone's been aware of them, and they've been existing for 8 months, 12 months or more. So these are people that everyone is fully cognizant of, fully aware of, aware that they exist and the expectations. And so the idea that we're going to strike a trial date that is 3 years in the making, 30 days out, just doesn't make any sense. They complain that my client somehow delayed the process because in October of 2023, it took him 7 days to sign an ROI because he wanted to chat with Ms. Rosen to make sure he understood what he was signing. Obviously, that didn't delay anything, and no one says that it did. So again, it doesn't make any sense. Their statements here are essentially, well, I want to be able to rehash the psych evaluation. That's what happens at trial. That's what trial is for. That's what cross-examination is for. Similarly, I think it's really important that we just note that my client has a right to finality. 3 years and tens of thousands of dollars later, my client has a right to be done and to know that this case is over. The children of this case have a right to be done and have permanence in whatever their plan is going to be. A new guardian ad litem, which is requested, doesn't add anything to this case but delay and cost. At this point, we have experts in the file. We have a psych report. We have counselors. We have reunification experts. What is a guardian ad litem going to do for the court? A guardian ad litem is then just going to weigh credibility. That's the court's job. It is not the guardian ad litem's job. So the guardian ad litem would then add nothing in a case like this. Counsel's statement that the children weren't school-aged, they were. The oldest child was school-aged, and now both children are school-aged. That's why reunification is happening where the children are located. Mother just doesn't like that that's what's happening because she's located here and they're located in the Spanaway area. So again, my client has a right to finality. Anytime we move a trial date and we push it off, it's going to inherently increase costs. And this is true. This is currently setting as a first set. We're in that first week of October. It will be increased fees for my client, which is substantial in this case. There's already been a significant expenditure of fees. It's absolutely prejudicial to just continue to push it out. And honestly, I think it's more, hey, I don't have the evidence I want yet. I want to wait until I can try to develop a little bit more evidence so that my case is better. But that's not a reason to delay trial. You have the evidence you have. There are, I'm sure, all kinds of cases that would like to push out and hope things get better, but that's not where we are now. And everybody has sort of dealt their hand that they're dealt at this point, and we need to go to trial and have a decision. So I'm asking the court to deny the motion, and in this case, award fees. I'd ask for 2 hours of my time.
Ms. Gilmore?
This isn't a case where we're trying to manipulate or delay the situation to create a different reality. It's simply a case where we just don't have the evidence at no fault of my client. And the records show that my client repeatedly has attempted to comply with the orders for the last 12 months. We don't have a completed psych eval based on the recent email from Dr. Deming. We do not have a recommendation for visitation from the reunification counselor. We do not have a GAL report despite the court ordering one in May of 23. So all we have before the court is things that are ongoing. I brought this motion again to reduce costs in hopes of avoiding trial preparation prior to the 30 days. So we do ask the court to strike the trial, to reappoint a guardian ad litem, and we'll set a new date once we have that information.
All right. So I tried to make heads and heads or tails about this case, and it looks like there was an order entered in September by Judge Fassett, and I don't know where that came from. This is the one that talks about it's a counseling order and some things.
I believe it's in response to their motion for an immediate restraining order.
I think that's, well, it depends on the timing. So by the fall, the court ordered the.
Well,
what
let me say what I'm saying is I don't know why we're at where we're at in the case. I don't know where that order comes from.
Mhm.
So my thought is Judge Fassett, at least when she ordered that order, would know what she was looking for. My thought is to put this on at 8:45 on Friday for her to determine whether or not she thinks there should be, the trial should go forward in the current status that it's in or not.
That's fine.
I just don't know enough about the case. It looks like there's been a lot of things going on in this case. And I spent about an hour and a half trying to read back through and figure out how we got where we're at today. And it wasn't real clear to me that how we got here. So.
And I think Judge Fassett, I don't know that anything has come before anybody else really after.
Well, Judge Scudder
Fassett.
ordered some stuff, but I think that was mainly related to property and maintenance. But
Yes.
the order that I'm looking at is the one that's dated September 8th. It's clerk's paper
23.
257.
Yeah, that's fine. 8:45
So I'm going to put it on 8:45
this week though.
on
correct?
the 6th.
That works for me.
And then she can take a look at it and see if she thinks it's ready to go or not.
Very good.
Do we need to get bench copies to her, or is she just going to?
It'd probably be useful if you have that available.
Okay.
I don't know that I do have a bench copy that I can, from Ms. Baldwin, I can pass on. I don't know that I had one from your office.
I'll do the same.
We'll make sure we send it electronically as well.
Okay.
Good morning, Your Honor.
Good morning, Ms. Gilmore. Good morning, Ms. Baldwin. Excuse me. All right, what are we doing here?
Why are we here? Judge Bashor kicked it to your docket because he thought you were better equipped to rule on my motion to strike because you were the judicial officer in the fall of last year that ruled on reunification counseling. I think that we both emailed our materials to you. I can make brief argument if you like. The long and short of it is my client has worked diligently to comply with the court's orders, and we're simply not where we need to be for trial. Reunification counseling just recently started. We don't have a visitation proposal from the reunification counselor. The psych eval is still being collateralized, so that's not finalized. We received an addendum last week that needs to be collateralized by my client, so that's not finalized. The court appointed or reappointed the guardian ad litem to provide a report. She's frankly, Ms. Gravina has fallen off the face of the earth. I have had no communications with her despite our efforts since the fall. She changed her address. And so when we attempted to pay her for her services for said report, the check was returned to us. And then my office made multiple attempts to contact her to make payment made. So we don't have a GAL report. The last GAL report was from February of 23 that recommended 50-50 custody or visitation between the parties. So we need a recommendation for visitation from the reunification counselor. We need a finalized psych eval. We need a updated GAL report pursuant to the court's orders. I do understand counsel's argument regarding finality. However, these children also deserve a final parenting plan that's in their best interest and a relationship, frankly, with their mother. Father had no problem with striking prior trial dates out that were at his advantage because we just received an updated GL report in February of 23. So I do think that we're premature here and we just simply don't have the information. I frankly have never worked on a case so diligently and my client working so diligently with no movement. I don't know if it's provider unavailability because of COVID or whatever it may be, but I can affirmatively say it's not at the fault of my client. And I think that's detailed in the emails.
Okay, and so the last name, and maybe I'm wrong, I see an updated statement of concerns from the GAL in June of 2023. Is that the last we've basically received anything from Ms. Gravina?
Yes. Yeah.
Okay, I just wanted to make sure. All right, thank you, Ms. Gilmore. Ms. Baldwin, good morning.
Good morning. So in this case, we're directly opposed to a continuance. So we're setting, we have a first set trial set for next month for October. At this point, this case has been pending for 3 years. Ms. Gilmore has been on the case for more than a year. Children have lived with my client exclusively since 2022. At that point, Mrs. had supervised visits. The children then made further disclosures, unfortunately, of sexual use And then that resulted in the position that we're in now, where mother's visits terminated for a period, and now we're working through reunification. Children have had specialized counseling. They continue to be in that counseling. So when you look at all of those conditions have been present for an extended period of time. These are not new things. These are not new revelations. These are all things that have been existent in the case for more than a year at this point in time. The psych eval is finished. That's why we filed it. Ms. Gilmore's client doesn't like what it says. She doesn't like the addendum that essentially cleared up a couple of the facts where the psych eval said, well, if these conditions were true, then this would be my concern. And we said, well, actually, this was the condition, essentially the ages of the children at the disclosures. That was the addendum. To get anything else requires them to re-engage that professional and pay her. And I haven't seen any of that happen. So we do have a final psych eval at this point. My client has not delayed this process at all. They sort of try to hoist that on him because of essentially a 1 week delay in signing an ROI back more than about a year ago. That doesn't make any sense. There was one continuance when the case, I think it was actually before the case was set for trial back in 2023, and this case was previously set for trial in early 2023. So this, again, not as if this is our first setting. There have been no moves to depose anybody. I haven't seen any subpoenas to any experts or any of the involved professionals from Ms. Gilmore's office. So again, sort of this idea of, well, I don't have what I want. There are ways to obtain those materials. I don't see them engaging their own experts to obtain the things that they need or want, or to make something different. It would be wildly prejudicial to my client to continue at this point. We are getting ready for trial. My year 904 is essentially complete and is going out today. Anytime you delay a case, it's going to result in higher costs. That is just absolutely the case. And so in this case, when I don't see any efforts to hire their own experts, no efforts to obtain records, to depose anybody, to subpoena anybody, and asking for a delay does not make sense. My client in this case has spent close to $90,000 to get us to this point, to get finality. So just kicking the can down the road is frankly just a terrible result. There's also a request for a new guardian ad litem. Again, this is a delay with no benefit. What would their purpose be in the case like this? To summarize expert reports for the court, who's frankly more equipped to read them than the GALs are. So I think that that's a cost with zero benefit to these parties. It's just, hey, can I get one more bite of the apple for some biased person to make a recommendation in my favor? We have a expert psychological evaluation. We have multiple counselors of these children who are experts, and we have a reunification expert who I believe is a PhD level provider. So all of these individuals are far more capable and equipped than a guardian ad litem, and the court is more capable than, frankly, a guardian ad litem after receiving those expert reports and information to then make a final decision. So again, my client just wants finality. No case is perfect when you take it to trial. That's just how it is. But it can't be that you get a delay because you don't have the evidence you want. Sometimes you have the evidence that you have, and you just have to go forward with what you have. And that's where we are. 3 years is long enough. Everyone is entitled to finality.
That's a few questions. So the psych eval looks like that returned on June 12th, 2024, but then there was an addendum or an update that was filed the 27th, or not filed, but submitted to the parties on the 27th of August. Is that approximately fair as far as timeline?
I think that is fair.
And I think it's important to note that my client wasn't provided any notice that she intended to do the addendum. So we were frankly shocked that we received that. And so I've been in communication with Dr. Dimming, and she plans on further communicating with my client without additional costs. So this was blindsiding to us.
I get that's not in any declaration though, and I haven't seen anything about that.
Well, as an officer of the court, I can tell you that I've communicated with Dr. Dimming, and she's going to be communicating with my client about the addendum and providing a response.
All right, I'm trying to get a time frame here. So the most recent information from Northwest Family Psychology was received August 27th, approximately.
Yes.
We have a GAL report that's, I guess the most recent update from that would be June of 2023.
Correct.
We have the reunification process started in October of 2023. Is that fair?
I think it started more at the beginning of this this calendar year. So to get everyone involved and engaged, it took a little bit of time. So I think that I want to say they started in January, but
Yeah.
it was just with the parents, and now it is the parents and children together.
Okay, so I do see January 14th, 2024. There's been an intake with Miss Gibson, an intake with Mr. Gibson, a review of paperwork, a consultation, referral for sessions for Miss Gibson, and a review of a report from Allison Long.
That all sounds
And,
correct.
and because the psych eval could not be completed without Ms. Gravina's input, there was delay. So I believe the reunification with the children of my client didn't actually start until June of it. So like in the last couple months. The first session with the children of my client have been in the last couple months.
But I don't think that had to do with the psych eval. I think that's just based on what the reunification counselor believed was appropriate.
All right. Most family law cases that go to trial, you're not going to have a reunification counselor specialist. You're not going to have a psychologist available to testify. And those are just the two folks that were included in Ms. Baldwin's response here. A GAL, whether Ms. Gravina can testify at trial, obviously is up to the parties, if she can be found, I guess. But at this point, I'm going to deny the request to appoint a new GAL. I don't think there's any need for that when we have the level of expertise of folks that have been working with these parties and these kids for at least the last 9 months, if we're talking about reunification. And I know that Ms. Anderson and Dr. Rosen, at least I remember seeing things that they were, at least last fall, were working with the kids. So I think a GAL at this point is really isn't going to add much for anybody. So I'm going to deny the request for a GAL. As for the motion to strike trial, so I understand that Ms. Gibson's position, and it does appear to the court that there has been, to be very frank, a drastic change in her involvement in this case. I'm happy to see that she's been productive in the last 9-12 months. But a lot of the delays that are listed are really of not anybody's fault at this point. Looking at, let's see, Ms. Gibson outlines kind of a time frame for everything playing out, and her concerns with needing more time. It's going to be a time crunch, but I don't see that there's a need to strike the trial at this time. So I'm going to deny the request to strike the trial. This is a 3-year-old case. There's been so much happening in this case, and frankly, there was a large portion of time that was lost because of Ms. Gibson herself. So at this point, we have evaluations, we have reunification set up. There's going to be at least another month worth of information that can be gathered from the parties, from those folks prior to trial. And I think we do need to move forward. So I'm going to deny the request.
Understood. Can Your Honor just enter a bench order, or?
That works for me.
Unless somebody else wants to do something, I'm happy to just do a bench order saying denying the GAL and denying the motion to strike trial.
That's fine.
Thank you.
All right. Thank you. Good luck. Right, we can go off.
And so looking at this just before, I'm not sure if this is something that we should be dealing with on a docket matter, or if this needs to have some sort of an evidentiary hearing. I'm fairly familiar with the case. I did the original dissolution, a couple of the modifications. So does council want to deal with it on a docket, or do you want to do a hearing on this?
But rather, I don't know, it's up to you, Judge, whatever you're comfortable doing. Just the language in that 2017 order states either party may docket the matter be heard on the regular domestic calendar. You were the one that heard that back, I think from the inception. I think you did a BSC back in 2015.
Which order were you referencing?
The 2017 order. May 12, 2017 family law order on hearing, maintenance review. Either party has the money to come in for a formal evidentiary hearing. If you want more information, get more information. I don't know if that's necessary either, but.
Okay, well, we can proceed on it.
And that's how we did that at the last time in 2017. You kind of handled this since the BSC when Ms. Cotto and Mr. Falkenstein were involved. I took over in 17. We had a motion and argument in front of you over at the juvenile hall. And here we are.
Okay. Well, I'm fine moving forward. It wasn't clear to me exactly what all the incomes were. I think I know where we're at, but.
Okay.
So.
Well, and you know what's happening here. You read the file, I presume, and the motion and looked at what was provided, excuse me, from both parties by way of income. And again, just to refresh everybody's recollection, this is one where parties were separated back in 2013-ish. My client was 2012. My client was ordered to pay a significant sum of maintenance throughout the temporary orders on this case. Parties conducted a binding settlement conference in front of your honor. You had basically given Mrs. Johnson her marching orders to seek employment. At the time, she had shown interest in real estate as well as Aveda, I believe was the name, which is some kind of massage therapy, I believe. That was her indication at the time of the BSC. You would put that in the final divorce order that she was to do that, and that maintenance would essentially be granted on that basis, but reserved and reviewed a period of time later. That was in 2017. You had lowered her support from that time from $1,750 at the BSC to $1,000 per month at that hearing at the juvenile hall, as I discussed previously, and then set another review for the time that my client reaches 62 years of age or contemplates retirement or Social Security benefits. He's now 65 years old. Work, as you can see, has slowed down. By my math, this puts him at about 11 years of maintenance, 11 to 12 years of maintenance paid on a 28-year marriage, in which the court wanted to, essentially just come back and review that given the timing of everything. We've showed you that he is now earning significantly less as 65 years old. Your body breaks down. I think that's kind of what has happened to him. He would like to be retired, but retirement for him is kind of based on this maintenance notion and what the court does with this today. So I would certainly submit the fact that he's waited 3 years beyond the duration that the order from 2017 contemplates shows that he's here in good faith. He's here trying to get some kind of resolution so he can plan his retirement, plan his Social Security, and go from there. So that's kind of the starting off point for that. It does not appear in my review of the responsive materials from Ms. Johnson that she's doing anything different than she was 8 years ago. She's currently working at Nike, continues to the best of our knowledge to live in the Pearl District in Portland and rent. Don't know if she has any assistance from that. Don't know if she's gotten any inheritance from her mother who has recently passed away. We don't have any of that information, but nonetheless, here we are. So we are asking that you eliminate or alternatively reduce my client's spousal support obligation, recognizing that he's paid now almost 12 years on a 28-year relationship in a case where Ms. Johnson continues to largely just kind of go through life. She's supplementing her income from Nike with that of the maintenance. We think it's been long since time she could have gotten her real estate license, long since time she could be a broker by this point, a long since time that she could have advanced her career, but largely chooses not to. And that's your words from 2017, not necessarily mine here in 2024. But we are asking you to eliminate that support obligation or alternatively reduce it. We did provide under sealed a copy of my client's 2023 W-2 that shows total income for last year of $78,832. We also provided you with his Social Security statement, which shows that benefit at about $29.97 per month as an estimate for his Social Security income that he will receive. That's what he has. That's what there is. If you look at the pay stub we provided you, it shows that he's not going to earn near that $78,832 that he did last year. That continues to go down as he's working less and less in hopes of retiring very soon. That's where we are. If you need more information or have questions, I'll be happy to try to answer those, but we are asking you to terminate the support obligation given the information and the standard of both parties currently.
So I guess just for clarification, I've got him at the $29.97 and change for Social Security, and I think I had it at $35.97 on earnings based on the pay stub.
Well, I'm sorry, what's that?
Based on the pay stub.
Run that by me again. I was looking at the Social Security statement.
$35.97 net on the pay.
Oh, yeah, that sounds about right.
So it's about $65.90 combined. That's what I come up with.
Well, I mean, on the pay stub, if he retires, obviously that money's going away.
But I guess I don't know that is he retiring? I mean,
That's depending on what you do today. Yes, if he can afford to retire, he would like to do that very soon. And that $29.97 gives you the estimated retirement for May of 2025.
okay, what I don't know, this is why I guess I may need more information, is I know looking at the pay stub, there's $2,100 in 401k deduction out of that paycheck year to date for that period of time. So obviously there's at least one 401k. So I don't know what his retirement income is going to be at this point. I mean, it's going to be more than $29.97 because he's got 401k income and I don't know what else.
So I think we need to just be cognizant that we're not double dipping for that, because that 401k that was initially divided during the divorce has already been accounted for.
So I understand that, but I mean, currently I don't know what he's going to be drawing. I don't know what his income is going to be if he retired tomorrow.
401k in
Yeah.
May of 2025.
Well, if he retired today, he'd have the $29.97 plus whatever
401k.
the other stuff is, and I don't know what that is.
Okay.
So without that information, I mean, I don't know where he's at. I mean, right now I've got him at $65.94.
But he's not currently collecting on Social Security.
Okay, so you got $35.97 he's not collecting. So maybe I misunderstood.
Well, that $35.97 is what he's getting net income now while he's employed, while he's working.
Okay.
So that goes away when he retires. Let's just call it May of 2025. That goes away. So his two sources of income in May of 2025 will be the Social Security,
Mhm.
and that $29.97 plus whatever he draws for the 401k.
Okay, so
That's to be determined.
I guess I was confused on your documents because I had him down for both of those coming in. So he doesn't have the Social Security coming in.
No, he's not getting any Social Security right now.
Okay. Okay. Well, let me hear from Ms. Bliss and then I'll see if I need some additional.
Thank you, Judge, and you mimicked my concerns, is we don't have the full picture. What's before the court is Mr. wanting to reduce his spousal support obligation because he may retire. Again, you mimicked what my client put in her declaration, is there are 401k, there's at least one 401k. One was partially divvied up during the divorce. I understand he's still contributing to a 401k. We don't know what that dollar amount is. Further, my client provides in her declaration, she's concerned about the transparency of Mr. only providing a W-2 and not a tax return. My client does believe he has other sources of income that he hasn't provided to the court. Again, that is speculative at best, but without a full picture, it's hard to determine what exactly his income is. Further, I don't see a budget provided from him showing that he has no ability to continue to pay spousal support. But what you do have before you is my client's budget, and it shows that without this spousal support, she is grossly in the red every single month. She has gained gainful employment at Nike and has been there for several years at this point, earning more and more income as the years go on, but still, nevertheless, she's only earning $21.18 an hour. Even with Mr.'s reduced income or reduced hours, he's still earning double her wages. At this point, the crux of my argument is we're putting the cart before the horse here. He hasn't set for retirement. We don't know the full picture of what he will be earning when he does retire. I believe that we're here prematurely, and we are asking the court to deny the motion or at least require more information be provided as to what that picture looks like upon his retirement. Again, there is a gross disparity of incomes even with his reduced wages. My client did make a request for fees for purposes of today's hearing, and that's our position.
And again, it's built
Well,
in.
let me stop you, counsel. So Ms. Bliss, I'm actually showing, if I look at purely income, if I don't include the Social Security, she's earning more than he is net without any maintenance. If I'm looking at the numbers that I have in front of me, that's why I'm confused.
Maybe that was my confusion as well. I may have been calculating him getting that Social Security and his income.
Well, and this isn't difficult. This isn't a full picture type of an argument here. That would have been what they argued back in 2015 during the divorce. Full picture is this: he's going to, when he retires, whenever that is, get his Social Security and whatever his 401k is. It's kind of not necessarily relevant because anything in that 401k was earned post separation. So that would be his separate property, which is why we can't get into this double dip of the 401k, which he's going to have 11 or 12 years worth, which is his. He's got Social Security. By the very term of retirement, your income goes away because you are no longer working. So we've got two very basic, which is not uncommon sources of income. You've got Social Security, and you've got a post-separation, post-decree 401k that he's been contributing to. Court's looking at this and needs to go back to 2015 and look at it at that time. The order specifically says from 2017 on that review, when the husband either retires reaches the age of 62, and again, he's 65 now, or commences the receipt of Social Security benefits, he doesn't, but we still provided you that information. Court will retain jurisdiction to review and determine what, if any, transfer of maintenance is appropriate at that time. You've already gone through the factors of RCW 2609090. You've already contemplated that back in 2015 at the BSC. To have a full picture at this point, I'm not sure what the reference is. You've already got it. You know what his Social Security is going to be. You know there's going to be a nominal 401k. I mean, very common and very typically people this age at 60 to 65 contribute as much as they possibly can to that, knowing that's going to be a pot of what they can draw from. I don't know if she's got a retirement or not. I don't know what she's been doing by socking money away into an IRA. We don't know what her inheritance is. It doesn't really matter for purposes of today. This is a review of the 2017 order to see what he's getting in Social Security. As of this moment, he's not getting anything, but we provided you the breakdown of the 2997 that he will be getting once he starts collecting that, more likely in May of 2025. But it's broken down. You can see if he was retired today, what he would get. That's the analysis. Having further information, getting a full picture. I'm not sure how much fuller that picture can get with the information we've already given you. Yeah, 2856 if he was to retire today.
All right. Well, the order was specific that it was reviewable. It didn't indicate what was going to happen on a review.
Agreed.
And what I don't have a tax return. I don't know what his situation is. I mean, I know what I got one pay stub and I have one estimated Social Security. And all I have from her is I've got a pay stub and I've got a tax return.
The only piece of information I think we're missing is when he's going to retire. And that's, the chicken or the egg conversation of he isn't comfortable saying when he's going to retire, not knowing the outcome of this.
No,
if he's
paying
$1,000, he's going to continue to work. If it's less, then he can sit there and contemplate retirement. So I think the only information we don't have to complete the full picture, whatever that is, would be here is the day that I am confirming I am retiring, and it is going to be September 30th of 2024. But that really doesn't change the analysis for today. I wouldn't think.
Well,
you're smarter than I am. I don't want to argue with you, but I think that's the only thing that we're.
Well, I guess I'd like to see a tax return.
You want to
at
see
least a current
return?
tax return, because that gives me at least the same information from both parties. Right, so a 2023 tax return would tell me a lot. Because I don't have that. I've got two snapshots, one of a wage stub and then one of an estimated.
So let's do this then. How about I file his tax return and I'll try to get you the best as I can, a pin down date as to when he plans on retiring, and then it is what it is.
That's not particularly an issue. I was misunderstanding because I thought he was retiring or was collecting. So
what do you want to? He's 65.
No, I understand that. I get that. So if you can give me a tax return, I could probably just do a written decision based on that.
I can have you that tax return by the end of the week. Yeah.
And I can take a look at it. And I'm very familiar with this case. It goes way back. I did the original. I've done all the review hearings, but I think given where we're at and what we're dealing with, I'd like to see that.
Very well. Okay. We'll get that to you shortly and look forward to a response.
Okay. And then I'll get a written ruling out very quickly on that one.
Okay. All right. Thank you.
Okay. Thank you, Judge.
Welcome. Mako and Krakenberg matter. Did you have a chance to review those documents, counsel?
Yes, Judge. Counsel did email those over to me and I was able to review those.
Okay. And I did review both the motion and the response. And if you'd like to flesh out a response to that, you give you some latitude on that, obviously.
That's fine, Judge. And I don't think that there was some new information within the response. I haven't had, although I've read it, I haven't had the opportunity to review with my client. But nevertheless, I do think that the main issue before the court today is whether or not this child should be allowed to move schools. Obviously, this motion in order shortening time to prevent the move, my client was on an 11th hour filing. As you saw in the record, this was filed on Thursday because that's when we got confirmation from Ms. Petrie's office that Ms. Krakenberg did intend to enroll the child in Napavine, and with school starting, we were on a very short turnaround. Nevertheless, the parties had previously agreed to have the child go to Castle Rock. The guardian ad litem had recommended that the child continue to go to Castle Rock. The parties attended, whether my client's understanding was an orientation and a meet and greet with the teacher, or Ms. Krakenberg's statement that it was a screening to determine whether or not the child was to go into kindergarten. The parties had a joint agreement that the child would go to Castle Rock. It wasn't until I believe the 21st of August, so not even 2 weeks ago. Ms. Krakenberg apparently got a job offer at Napavine, unilaterally, again, decided to enroll this child into Napavine over the objection of my client. Again, this parenting plan requires joint decision-making. This is not the first time Mrs. has made a unilateral decision that has drastically impacted not only this child, but has impacted my client's time with this child. You likely saw very early on in the case, Mrs. up and moved to Centralia at the party's separation, changed his daycare up there, and essentially set up an entirely new life up there, thus cutting my client out of the child's life. The parties are attempting to negotiate a final parenting plan, but there are a lot of issues that still remain. One of which now being the child's school. The child grew up in Castle Rock, was previously supposed to attend Castle Rock, and now mother unilaterally again made that determination herself as to the child going to Napavine. I reviewed in her responsive materials that she's claiming essentially my client's objection is due to convenience. No, arguably, I would say that's Mrs. position. She now teaches at Napavine, therefore it's more convenient for her to have the child with her. I think this is a major decision that's going to drastically impact this child's upbringing. There's a recommendation of the guardian ad litem for joint custody. Obviously, this is going to need to be further flushed out. I don't think on this short of notice, over the objection of my client and without the approval of the court, that she should be allowed to enroll this child into Napavine and force my client's compliance or agreement with this. The parties do have joint decision making under the current parenting plan. So we are asking the court to restrict the changing of the child's school. We're asking the court to potentially have further discussions or further reviews to allow my client to provide further documentation as to why one school is more appropriate. But again, this backdoor, I'm going to enroll him in Napavine, even if you object and without obtaining a court order, is frankly in violation of the parenting plan. We could have brought a motion for contempt, but this is obviously a more time-sensitive issue that needs to be addressed before the court before this child has a drastic change in his life.
May I respond, Your Honor, just briefly?
Give me just 1 second. Maybe I'm looking at a different thing here. Ms. Bliss, you indicated that the guardian was recommending a joint custody plan.
That was my understanding, Judge. And I can pull.
It should be noted, however, that the GAL recommendations have not been adopted by the court. They are not part of the court order.
Counsel, I'm asking Ms. Bliss a question. So I'm just trying to, are you looking at a different report?
No, Judge, I was pulling up the final.
One I've got is from April.
Yes, and I believe it made mention, I was trying to recall where it was at. Once the anger management treatments are completed, Ms. Krakenberg and Mr. Mako should share a 50-50 parenting schedule. That's at line 409 of page 11.
It's a different report than I was referencing. I'm sorry. So,
sorry, Judge. Yeah, this is the April 24, 2024 final GAL report.
Okay, well, I just wanted to clarify that. Thank you. So, Ms. Petrie, go ahead.
Thank you, Your Honor. Your Honor, as to the Castle Rock, it was recommended, but it was recommended because my client was working there. Because my client is no longer working there and they do not live in the Castle Rock School District, he has to change schools. He's not eligible to go there anymore. We'll get it on another case. We'll get into the unilateral decisions regarding moving and all that. My client did receive this new job offer and it was a last minute offer. She had to figure things out. She tried to contact him and discuss this with him in a productive manner. And all he did was sling insults at her and scream and yell at her. So when she tries to engage in discussions for joint decision making, he won't engage in a productive conversation. Instead, he just verbally abuses her. She currently lives in the Napavine School District and she's working there. So it only makes sense, since she has the child the majority of the time, that he would go to school in the district that she lives in. Now, we're also not talking about a 3rd or 4th grade kid who's got, a few years established in a school. This is kindergarten. He's starting. So changing schools, there's nothing really big. And now he's actually going to be able to go to school with kids that are in his neighborhood that he knows. As far as impacting his time, I find that ironic that he's complaining about it, since he hasn't called the child in the last week at all.
And I would object, Your Honor, that's not contained in any declaration. It's not properly before the court.
Regardless, he's not even attempting.
I'll sustain.
Regardless, Your Honor, it doesn't affect his time. The current parenting plan, which is the court's current order, he only has to make the drive to Napavine once a week. And I think it's even once every other week. So it's not that much of an inconvenience. And yes, it would be incredibly inconvenient, especially come this winter, for my client to have to drive him up to Castle Rock, go back down to Napavine to work, go back up to pick him up. That's unreasonable to ask of her as well. Mr. has not completed that anger management evaluation, despite the fact that it was recommended back in April, and he's refusing to undergo his anger management evaluation.
I would also object this isn't in any declaration.
I'll sustain. Counsel, if you can stay within the declarations that were filed, please.
Fine, Your Honor. We did mention in there that he has not been in compliance. And this was a last minute thing, Your Honor, and because of his lack of cooperation and willingness to engage in productive, discussions about the child, my client was left with no choice, and she had to act because of the timing. So while counsel may represent that she did this knowingly, deliberately, unilaterally, she made attempts to discuss it with him, and this makes sense. So, and again, the GAL recommendations are not part of the court order. They have not been adopted. And the parties have been negotiating since April, trying to figure this out.
Judge, if I may briefly.
Sure, go ahead.
Thank you. Counsel indicates that mom is now living in the Napavine School District. That's news to us. Last we had heard she was in Centralia, so that may be another issue for contempt. Nevertheless, my client resides in Castle Rock. If nothing else, the child could attend Castle Rock because of my client's address. Joint decision-making under the parenting plan doesn't mean I make one attempt, it's unsuccessful, then I get to do what I want. That's not part of the order. That's not part of case law or statutes, frankly. If Mrs. wanted to make this determination, she should have brought this matter before the court. She should have sought other measures instead of self-help measures to allow her to continue the course in which she's on. Not only drastically impacts my client's time with the child and impacts the child, but is rewarding her again for bad behavior. So we're asking the court to restrict mothers changing of the child's school and potentially award fees in this matter for having to bring it before the court.
All right. Is Ms. Kale here today? I didn't specifically see her.
I didn't see her on either. I don't see her listed in the participants list.
Yeah. Was she given notice of today's hearing?
Yes.
Okay. Well, I go back to the parenting plan that's in existence, which does require joint decision-making on educational decisions. So that raises a concern. And in review of all the declarations before the court, sounds like that may have been less than fruitful, but it's still a requirement of the order. That being said, this isn't really a change of schools. We have a kid who's in pre-kindergarten, and then we now have him. This is a kindergarten situation. These are temporary orders that do not necessarily have any impact on a final order of the court. And the court could very well require that he go to Castle Rock School if that's what seems appropriate at a final hearing. Again, I am concerned about not following the parenting plan. That's problematic just in general. So, I mean, currently the father has three visits a week. Is that right? Am I get that down right?
I think the temporary order has him on first, third, and fifth weekends from Friday morning till Sunday afternoon.
Okay.
That sounds correct to me as well.
Okay. So at this juncture, I'm going to leave the child there, and that's in part because the parenting plan that was entered places the child with the mother. I don't have any indication in the parenting plan where she was living when that was entered. If it was in Lewis County, then Napavine and Chehalis are literally a stone's throw across the freeway from each other. So that's frankly not something that I'm too excited about, other than the not following the decision-making portion of the parenting plan. I mean, that is some implication as to whether or not people are willing to follow the requirements of the court. In the short term, I'm going to leave the child there. And I think right now, let me see here. Right now, they're exchanging at the Space Age fuel station. That's actually probably closer to Castle Rock, so that'll remain the place.
Judge,
changes.
Judge Bashor, excuse me, this is Guardian Ad litem Beth Fellows. I texted Heather Kale and she said that she's in the waiting room right now.
Oh, thank you. I'll bring her in. Ms. Kale, are you there?
I am. My apologies, Your Honor.
That's all right. We're talking about the Mako and Krakenberg case.
Yes.
Do you have any thoughts on the request that's currently before the court?
I don't believe I've been informed of the request that's before the court, Your Honor.
Did you receive the motion or anything?
Not that I'm aware of. I mean, unless I'm terribly mistaken, but I am not aware of what's in front of the court today.
Okay.
And Judge, looking at my confirmation of service, it looks like it was just sent to Ms. Petrie, given Ms. Kale is no longer actively involved in the case.
Okay. Well, the situation is the child's been enrolled at the Napa Vines School District based on the mother having been offered employment there a couple of weeks ago. And so the motion before me is to require that the child go to Castle Rock School, which was what was in your recommendation. And so I guess that's really the issue right now. This is a temporary order, has little, if any, impact on a final order. So do you have any thoughts on that issue?
I have a little bit of concern for how that impacts father's visitation, given the amount of transportation that will require. However, I do believe Ms. Krakenberg should be able to take a position that's been offered to her, especially if expectation is that she can become financially independent and provide for her son.
Yeah, this would leave the exchange place at that fuel station just north of Castle Rock. That's what
Okay.
that's what the temporary order has, and I wouldn't change that.
Okay. I think as long as that's fair, I mean, as long as that's still possible, I think it's a fair request.
All right, so I'm going to leave that in place. That was kind of the direction I was going. So the child will be allowed to stay at the Napa Vines School District at this point. Again, that may be something different when we get through a final outcome of the case. Again, I am concerned about the not following the joint decision-making provisions, and that'll be something the court will be looking at as far as final orders. So deny the motion. I'm not going to grant fees at this time.
Okay. And did you want to just enter a bench order, just motion denied, or do you? I can prepare a formal order. I figured it'd just be a one-liner at this point.
I would have counsel prepare something and shoot it in for both parties to sign off on.
Very good. I can prepare that. Thank you, Judge.
Right. And a copy that should go to Ms. Call until she's formally discharged.
Yes, Judge, that was my mistake. I thought the new orders have them immediately dismissed once their report is finalized. So I think that was just an error in my database. I'll fix that. Thank you.
Okay, that I wasn't aware of that. So, but in any event, I assume she's still involved until she's not. So,
Very good.
Thank you, Your Honor.
Okay, thank you, Ms. Call.
Thank you.
All right.